Today, in the modern global economy, mobility of a workforce plays a large part in business and recruitment plans, which means that HR professionals have to increasingly navigate the minefield that is the UK immigration system. So, what are the main factors that you need to know in recruitment? Well, under the UK immigration system, there are 5 main tiers. There's Tier 1, which is for highly skilled migrants, Tier 2 for skilled migrants, Tier 3 for unskilled workers, which is a category that's currently dormant, Tier 4 for students, and Tier 5 for temporary workers. Well, today I want to focus on the Tier 2 category, and this is the category where employers sponsor overseas workers to work for them in the UK. However, just before I do this, I just wanted to run through some of those categories where some of those individuals don't need permission to work in the UK. It's always a good idea to think about this and consider this first, because if they don't need permission, then it's not something that you have to worry about. This includes British citizens, although British territory citizens and British overseas citizens do require immigration permission to work in the UK. Employers must be careful as these passports look like British passports but offer no right to live and work here. Secondly, those who have the right of abode in the UK don't need specific permission. Thirdly, those who have indefinite leave to remain in the UK, which is also known as settlement or colloquially as permanent residence, can live here without specific permission. Carrying on, EEA nationals don't need specific permission. However, citizens of Romania and Bulgaria do not have an automatic right to live and work here, and therefore they must apply for a work permit and an accession worker card. These restrictions will remain in place until at least the end of 2013. Further, Swiss citizens don't need permission to work in the UK. Following on, Commonwealth nationals who have a grandparent born in the UK or British Islands don't need specific permission to live and work here, as don't spouses of British citizens, EEA nationals and Swiss nationals. Finally, dependents of individuals granted immigration permission to work in the UK. But please note, with these individuals, they must establish their relationship with the migrant and obtain entry clearance before travelling to the UK. So as you can see, a large number of people don't actually need specific immigration permission to work in the UK. So it really is a good idea to have a look at this list first before deciding what other immigration permissions people need, because sometimes they just don't need any. So it's always a good idea to do this because you can save yourself a lot of time and trouble and work. So moving on to the Tier 2 scheme, this is where skilled workers come to the UK to fill gaps in the labour force, i.e. this means when an employer has been unable to recruit somebody from the UK or the EEA area and they need somebody to do a specific job. In very simple terms, there are 4 stages to this process. The first stage is where the employer actually applies for a sponsorship licence. The second stage is where they then check the credentials of the individual and to check that they've got sufficient points in order to be able to come to the UK. The third stage is when they issue the individual with a certificate of sponsorship. And then the fourth stage is where the individual themselves goes and gets entry clearance to be able to come to the UK. So looking at this in more detail, I'm going to look at stage 1 first. This is where an employer has to apply for its sponsorship licence to the UK Border Agency. This is an online application. It takes about 30 minutes to complete as long as all the relevant information is in place. This information includes things like the company accounts, business registration. It's really the information that shows that it's a bona fide organisation. Once submitted, an employer then has 14 days in which to send off their application fee to the UK Border Agency. If an application is refused, there's no right of appeal. However, an employer can submit a further application at some point in the future. Once an employer becomes a sponsor, it has fairly onerous reporting obligations to the UK Border Agency. This includes reporting to them when an individual doesn't turn up for their first day at work, if they go absent for more than 10 days without valid reason, if their circumstances change at all, or if there are any suspicions of the leave of their conditions. All the reporting between an employer and a UK border agency actually happens online, and therefore it doesn't mean that you have to be on the telephone to them every 5 minutes. You can actually notify them by going online to them. Moving on to stage 2 then, before issuing a certificate of sponsorship to an overseas individual, an employer must be certain that they are unable to recruit a suitably qualified individual from the UK or EEA area, that the individual scores sufficient points prescribed by the UK Border Agency, and that the individual satisfies all of the required criteria. So how do you do this? Well, firstly, for all jobs that don't appear on a shortage occupation list, they need to be advertised. And they need to be advertised in prescribed locations such as national newspapers, journals and on the internet. The UK Border Agency Code of Practice actually stipulates where jobs of certain types need to be advertised. So the advert needs to include things like the job title, the terms and conditions of employment, any skills and qualifications that are required, the salary on offer, and also the closing date of the application. If the job's on a shortage occupation list, there's no need to do this. This list is available on the UK Border Agency website and details jobs for which there are deemed to be a shortage of qualified UK or EEA workers. Secondly, the vacancy must be at graduate level or above, and you must also check that the salary is at a level required by the UK Border Agency compliance. This information is available online. Thirdly, you must check that the individual can score sufficient points. Basically, they need 70 points, and these are awarded in different ways. There's an online calculator that you can check this, but in brief, they can score 30 points for being issued a certificate of sponsorship, 20 points for having the relevant salary level, 10 points for English language skills, and 10 points for their maintenance. In order to obtain the necessary points for English language skills, an individual must either come from a majority English-speaking country, such as America, or Australia, have been taught their degree in English, or pass an approved English language test. To obtain the points for maintenance, from the 14th of June 2012, an individual must have at least £900 in their bank account for themselves and £600 for each of their dependents. This must be in their bank account for a consecutive period of 3 months immediately prior to the date they make their application. Alternatively, an employer can give an undertaking in place of the maintenance fund requirement. To do so, they must send a letter to the UK Border Agency on letterhead containing the following information: the names of the migrant and all of their dependents, the certificate of sponsorship reference number, confirmation that the sponsor will maintain and accommodate the sponsored migrant and their dependents for the first month in the UK should it be necessary, and whether the sponsor is limiting the funds they offer and what the limit is. When an employer is happy that all of these stages have been completed, it can then move on to stage 3 and issue a certificate of sponsorship for an individual. For individuals earning less than £150,000 a year, certificates of sponsorship are restricted. For the year April 2012 to March 2013, the government has restricted them to 20,700. However, it's worth noting that for the year 2011 to 2012, less than this number were actually applied for. Certificates of sponsorship are a number issued to an applicant and not a paper certificate in the true sense of the word. Once issued, they are valid for a 3-month period, and if the migrant doesn't use them within this time, then they become invalid. Stage 4 of the process is for the applicant to complete. Once they've been issued with their certificate of sponsorship, they then have to apply for entry clearance. This is often called a visa, or known as a visa, and used to be, until very recently, a stamp in somebody's passport. Now, an individual is issued with a biometric residence permit. In order to do this, they have to have their biometric data taken. The UK Border Agency will take their fingerprints and also a digital facial image, which includes taking digital photographs of their iris. This information is then stored online and used by individuals when they come in and out of the UK. This actually replaces the old stamp in the passport, so it's very important that individuals do get this. For employers, in order to be able to check the biometric residence permit, UKBA have an online checking system, and this enables employers to go online quite simply and to be able to check the status of the individual and that they are legally required or able to work in the UK. In summary, the Tier 2 scheme is fairly straightforward and prescriptive as long as you follow the processes carefully. It's always worth taking account of the UK Border Agency processing time and ensure that you plan well in advance. If you have any concerns, I always advise that you seek legal advice, as to employ somebody illegally carries with it hefty penalties and fines.